Hi, I'm Elizabeth Talbot, and this is Matthew Talbot, and we're with the Talbot Law Group in Walnut Creek, California, and we're a trust and estate law firm. And today we're going to talk about revocable trusts and the things that get litigated most often with revocable trusts and how to avoid them in your estate plan.
Yeah, we're here to just try to help provide information. I know a lot of people are very concerned with the coronavirus pandemic about estate planning and making sure that their affairs are in order, and that's very prudent. But sometimes when people put their estate plan together, problems can arise, litigation can ensue. We've been handling these types of matters for over 13 years, and so I've seen every type of litigation, and so it's helpful to know what might happen when you're putting estate planning together to avoid that litigation. The first type of issue that can arise is if people wait too long and they put the estate planning together at a time when maybe they don't have capacity. This can lead families to fighting over whether or not mom or dad really wanted what they put in their trust or really wanted what they put in their will.
Or often it's just questionable capacity, isn't it?
That's
It's a
correct.
little bit tenuous whether their full mental capacity is there.
If they get into that gray area, that's a problem. So that's why we recommend strongly that people put their estate planning together as soon as reasonably possible. So that's the first issue. The second issue is that sometimes people will put co-trustees together who just can't act. They come in and they say, I want both of my kids or all three of my kids to manage my assets. And that may come from a good place, but unfortunately, sometimes those kids just can't get along, and then litigation ensues. We've had many cases involving the children, brother and sister, sister and sister, brother and brother, where they're fighting and they just cannot work together, and it's very unfortunate. And that's why we recommend people put one trustee on if possible.
And sometimes if they really feel they cannot choose just one child, that in itself would create a huge problem, then they can elect to have a professional manage their trust, which can be a great workable solution for many people.
That's correct. So another problem that can sometimes arise is when the mother or the father seeks to cut out a child when they have a non-natural distribution. It can create potential fights. And so we recommend that if you are going to try to cut out a child, that you have to have very clear reasons, justifiable reasons, and that we put that language into the estate plan itself so that after you pass away, if there is a dispute amongst the children, there is a lot of clarity regarding why you did what you did. I don't think that people would want their kids fighting, and this is one important way to avoid that fight. And then lastly, another type of problem that we see erupt is when there's not a lot of clarity regarding what assets are in the trust. And so we always make sure to put a clear list of assets that are being placed into the trust and then to supplement it over time. And so those are the four types of main disputes that we see. And when you're putting your estate planning together, you want to work with a trained attorney with years of experience so that they can see these potential problems and avoid them so that your family is not fighting over you, either at the end of your life or after you've passed. Thank you so much.
Thank you.